Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to another episode of Just Verdicts. We are flying along in this podcast, and the interviews and the cases get more and more interesting. And today is no exception, because today we're joined by attorney Noah Geary. And Noah, thank you so much for joining the show and for working through the tech issues to get set up today. Good to see you, man.
Thank you for having me and for your interest in the case.
Oh, major interest. I mean, I think 4 or 5 different people texted me when your verdict hit. Did you hear? Which I just love. I mean, it's just awesome. I can imagine the excitement and just how this must have felt for you and this family. And the first thing I thought was, I got to talk to Noah about this case. So why don't we start a little bit about you, Noah? So where do you practice? What type of law do you predominantly practice? And, how did you get to the point of trying a case of this magnitude?
Thank you. So I am 53 years old. I came out of law school in 96. I opened my own practice. My father, Mark Geary, is still practicing. We shared office space. My father had been a prosecutor and did a lot of criminal defense work. But at that point in his practice, he was doing a lot of estate work, estate administration, and real estate. I originally wanted to accomplish some things as a criminal defense attorney and try murder cases and some death penalty cases, things like that. But I also had an interest in civil cases, particularly civil rights and employment discrimination. So we shared space. I started my own practice and did a ton of criminal defense, but I also did civil cases. And as a young lawyer, I didn't do any type of advertising. So I didn't really get my hands on any good civil cases when I was younger, but I cut my teeth on smaller cases like everybody else does. And other lawyers, of course, have helped me, very kind. So if I had a medical malpractice case or a civil rights case, I had to make calls and seek guidance, which I did. And I knew over time, I'd probably burn out on criminal defense, which I have. I mean, I probably tried over 50, 60 felony jury trials, murders, rapes, death penalty cases. So as you know, Brendan, it's tough to get trial experience in civil court with the advent of ADR and just cases settle. So, but the whole time I was building my civil practice, and I'd say the last 10 years, I focused primarily on plaintiff civil cases. And so the civil rights cases, I believe, it could be the most challenging in the law, because with the immunity defenses of qualified immunity, absolute immunity, sovereign immunity, you don't get your day in court. You may get it, but unlike a factual dispute in, say, a med mal case or a trucking case, the defendants invoke at Rule 12, which is the federal equivalent of preliminary objections. You file the complaint, boom, Rule 12 motion to dismiss on the basis of qualified immunity or absolute immunity or sovereign immunity. And we're in the Third Circuit and very conservative bench. And so what's very frustrating is right off the bat, if the way the judge construes your complaint, they may grant qualified immunity before the defense even files an answer. So your case is gone and you didn't even get to do one deposition. Then you go to the Third Circuit. I've had some excellent cases, truly excellent cases, disappear on me at Rule 12 and at Rule 56. Very frustrating. Then if you get by the Rule 12 motion, you work the case up, and of course, summary judgment, they can re-raise it. What's frustrating is, even if you beat the Rule 12 or the Rule 56, right then, pre-trial, the government official can appeal the denial of qualified immunity. So if I win at Rule 12, they can appeal right there. So that's a year delay, 12, 18 months. If I get by summary judgment, that's just for a moment, because the defense, they can take it up there. So I've had one case recently, it went up to the Third Circuit 3 times before I tried the case. So that's 5-7 years of delay on top of the delays that are already built into the system. So very frustrating, but so tragically, this occurred in 2017 with the Gallo family. They called me. At this point, I've done every type of civil rights case, deadly force, excessive force. And as we see on television throughout the country, there has been, in fact, a spike, certainly over the last 10 years in this country, in use of excessive force. And a lot of bad things are going on out there.
Well, let me ask you about that's an interesting point. So, do you, in your estimation, do you think that there has been a spike, or is it also the fact that people now have phones and there's better ways of documenting things that occur, body cams and so forth? And I guess it's we could debate about it, but was this just the way it always was, and now it's being brought to light more, or do you think that there's something where literally the rate of excessive force is increasing?
The rate of excessive force is increasing. I mean, that's my view unequivocally. Again, I came out in 96, and generally speaking, I'd say when I came out, so with my criminal defense practice, I mean, I was in court several times a day on criminal cases, so I'm going against the cops all the time. And I'd say when I came out in 96, I would say 1 out of 5 cops were looking to escalate a situation. Okay. 1 out of 5. Could have been a little higher, but I'll be fair and say 1 out of 5. In the last 10 years, it's easily 2 out of 5, and if not 2.5 out of 5. So that goes from 20% to 40% right off the bat. 40%, that's almost half the situations. So there's this, it's nothing. People ask me, what about the training? Should the training be better? I think the training is fine. They just ignore the training. There are more officers now, for whatever reason. They want to mix it up. They want action. Of course, there's a bit of machismo in it, and masculinity and testosterone. So if an officer goes and de-escalates a situation and doesn't make any arrests, he doesn't have a good story to tell. But if he goes and, it's a big brouhaha or turns into a big brouhaha, then the officer has a colorful story to tell and this type of thing. So there's some motivations that aren't exactly pure that go into this, of course, as in any industry. But I feel most certainly absolute spike in the instances, the number of excessive force and the severity, separate from the advent of cell phones and video cameras on cell phones.
Noah, can you give me because I personally do not handle civil rights claims. Can you give me, and we'll stick with excessive force because that's what this Gallo case centered around, but kind of a primer for dummies on how, what is the basis, what's the constitutional basis for these claims? And, you talked about the hurdles, the procedural hurdles that you face. What do you have to plead, to make out your case, and what's your, the foundation of these claims?
Sure. Thank you. So it has to be a state actor. So that would be a police officer. Also, a little bit broader than excessive force. I mean, I've had cases against jails, prisons for deliberate indifference to medical needs of an inmate, suicide cases. But on an excessive force, it's a police officer, whether it's state trooper or municipal, and it's a seizure. So it's a constitutional right. To have a civil rights case, a constitutional right has to be infringed. So Fourth Amendment, a seizure. So if somebody beats a citizen up, an officer beats a citizen up, that's a seizure of their body. I get a lot of cases that are where there are technical violations, pulling someone over without probable cause in a search of the car connected to a criminal case, but it's a seizure. And then it's reasonable force. Did the officer use reasonable force? And that's an objective standard, which of course has in the law, the courts can interpret that any which way. Would a reasonable police officer in that situation encountering my client, would they feel that the force they utilized was objectively reasonable? And it's from the hindsight and the perspective of the officer, no hindsight, from the perspective of the officer and the totality of the circumstances. And so right there, the standard is tough for plaintiffs legally. Also, on a very real level, my client is having an encounter with the police. So they're a suspect of a crime. So right off the bat, taking the case, whether I'm in district court in Pittsburgh or in Third Circuit. As we know, it's not really supposed to be factored in, but it is. Well, Noah's client was doing something he shouldn't have been doing. So why would we really strain to find this from his perspective? So it's supposed to be from the officer's perspective under the totality of the circumstances. And so the defense here is qualified immunity. And that means the officer always invoke qualified immunity, meaning they say, the force I used was objectively reasonable. I may have made a mistake. I may have made an error of judgment. How I handled the situation didn't have to be perfect, but it's from my perspective. And Noah's client was on the ground. Then I had some other officers gathered around, and he appeared to be constrained, but I didn't know. And what if he was going to go for my gun? So if I tase him, Noah could say that's excessive, but that's easy for Noah to say that because I was in fear for my life. And the officers always throw out, I was in fear for my life, immediately, every time, as if that's the magic escape hatch. So you'll always hear that. And so, again, on qualified immunity, they raise that at Rule 12. If the judge goes for it, your case is gone. You're up to the Third Circuit. If you get through discovery, obviously you're trying to build facts to defeat QI, but they could raise it at summary judgment. Even if you win at summary judgment, they take it up. So by the time you get to trial, it's already been a long road. Here in the Gallo case, what I actually thought was honorable by the Attorney General Civil Division is they did not file a Rule 12 motion or Rule 56 summary judgment motion on the basis of QI. Typically, the defense will always raise it, even if the QI defense is frivolous and meritless. Here, I've had a minority of defense attorneys who are honorable and will say, yeah, Noah, it's true. If we look at this from both perspectives, a jury could go either way, so I'm not going to file it. So I did not have to deal with qualified immunity pre-trial. The defense did raise it at halftime of our jury trial, and Judge Colville denied it. I thought it didn't apply here, and Colville was correct in that ruling, denying the Rule 50 motion on qualified immunity during the trial.
No, in your time trying excessive force cases, have you noticed a change in overall jury perspective or perception of the police? To me, as an outsider, I don't handle these, but I recently, I represented a police officer who was a plaintiff, and he was very concerned about a lot of dislike for police. And I think, in the past, probably decades ago, police were held, in high reverence and high regard. I think that has maybe changed somewhat from a jury selection, and I hate to, paint with broad strokes like this, but do you feel like there's been somewhat of a shift in how the police and the government machine in that sense is viewed?
Yes, and I think the shift is a good one. It's not an extreme shift, but I think, at least from my perspective, in 1996, I would try criminal cases or civil cases, but especially in the criminal cases, in the jury questionnaire, are you more likely to believe a police officer than a citizen witness? Yes. I mean, if I had 36 people in the poll, 32 would raise their hand. Yes, I would believe a cop. Why? Because they're held to a higher standard. I'd say, what does that mean? And most jurors can't articulate it. But of course, I was born in 1971, so I was taught the police are the good guy. You follow your authority, you respect authority. So I think until about 10 years ago, I think there was a bias in favor of police by jurors in state court and federal court, that old time thinking, which I respected, and I grew up with that the police officers are not going to lie on the stand. They're not going to hide evidence. That would have to be that would be uncommon. They do the right thing. They're honorable. Now, with the spike nationally in, say, the last 7 to 10 years in the use of excessive force and other bad things by police officers, I think the shine is worn off, and I think more jurors they just see life more realistically. Police officers are competitive. They do want a conviction. Their competitive zeal is a motivating factor, not just the truth. And so I think jurors, which is good for plaintiffs, but it's good for the system and everyone, that the luster's worn off. That's a good thing. And they say, no, maybe these police officers are going to lie. Maybe they did hide evidence. So they're holding police officers to the same standard more so as to a civilian witness, because why shouldn't they be held to the same standard? And so it would be very, very difficult to get, in a lot of criminal cases I tried, a jury that was, I mean, I'd end up still with all my peremptories and challenges for cause it would be denied. I'd have 12 jurors, but in the questionnaire, I'd have 8 of my 12 jurors had answered, I'm more likely to believe an officer than a civilian witness on the same point at trial when disputed. So, yes, jurors, I think, are more open-minded and realistic with the truth.
So let's pivot into, this trial. And you tried this. Did this verdict come down in May?
May 29th, yes.
So it's, I guess it was the estate of Louis A. Gallo versus Weaver, and then a bunch of different people. Federal case, Western District of Pennsylvania, and you had talked earlier about the family coming to you with this case, and because of all these procedural hurdles and so forth, you have to jump through. That was back in 2017 that they came to you, right?
Yes, sir.
So give us a little summary of what this case was. Like, when it comes to you, what is the story that you understand, and then what do you start digging into?
Sure. So thank you. So Anthony Gallo was 34-year-old white gentleman, had a 15-year-old son, and he had been in a car accident a few months before this incident. In October of 2017, car accident as a passenger, and his head went through the windshield. I don't know if it went through the windshield, but impacted the windshield severely. And for the next number of months, he was acting differently to his family. Not violently, but just differently. So he sustained a head injury. He had a bit of a workup, but not completely. So on the day in question, on a Sunday afternoon, beautiful day in October, Sunday, he is at his grandmother's in a trailer park. Everyone's watching the Steeler game, and he's acting strangely. And to the family members. And he's saying, I need to protect you from the bad guys who are imaginary. And he's saying, I need you to count from 1 to 60 out loud and from 60 to 1 backwards out loud. They're saying, Anthony, we need to get you some help. We want to get you, let's take you to the local psych ward. So it's in a trailer park. So his mother is called. She goes over, and then he's walking outside the trailer park, and his mother's with him. And he goes into a trailer, and everybody knew him. And he did take a paring knife out of a drawer. He was taking knives. And the mom says, Anthony, what are you doing? Well, I have to protect you. You're my troops. So she says, Anthony, give me the knives. And these are just paring knives out of someone's kitchen drawer. She took all knives but one. He did end up with the paring knife, 3-inch blade, very flimsy, in his hand. She tells her sister, call 911. We got to get him committed. So her sister, the mother of Anthony, Betty Gray, has her sister call 911, and then another family member. So the family called for help. And on the call, they're saying he had a head injury. He's not been acting like himself. He is acting erratically. He has a knife. We want to get him committed. And so they're looking for an ambulance. Well, the police show up. And 2 state troopers, many others, but the first responders were 2 state troopers, a Chad Weaver and a Matthew Schaefer. Weaver was the defendant who shot and killed Gallo. Schaefer did not discharge his weapon, so he was not a named defendant, but he was a principal witness. So the mom has Anthony Gallo. He's 34 years old. He has a son who's 15. His son was not there, standing outside this trailer. So the mom has Anthony calmed down, standing right there, and willing to go to the hospital. So
his son was there. His son was there in the midst of this thing.
No, I'm sorry, was not there.
Okay, gotcha.
Yeah, the 15-year-old boy was elsewhere, fortunately.
Yes.
Trooper Weaver, principal defendant, shows up, and Schaefer. Now, on the way there, on the dispatch from the state police, it's man acting erratically, has a knife, and it's he's mentally having a mental health breakdown, threatening suicide. So they get out of their vehicles with AR-15s, and they come up and they see Anthony Gallo standing there with his mom. Now, They had dash cam footage, but it only showed them getting their AR-15s, and they go up and make a left. They turn the corner, and then you don't see them anymore. But it's undisputed that Anthony's standing there with his mom. They have AR-15s pointed at him at close range, and he's having a mental health breakdown. And they're saying, get on the ground, get on the ground. The mother says to the troopers, whoa, we called. Can you put the guns down? She's not expecting AR-15s pointed at her or her son's face. Can you put the guns down? Shut the fuck up. She doesn't know which trooper says that part of the language, shut the fuck up. And Anthony sees these, and he runs into the trailer. So there's a trailer there. He runs into it away from them. He's got the knife in his hand. One trooper saw the knife. The other trooper, Weaver, the shooter, says he didn't see the knife. So as soon as he runs into the trailer, away from the troopers, the mom's, one of the troopers says to the mom, is there anyone else in that trailer? No. Can you please put the guns down? Weaver goes in first, and then Schaefer. They go in that trailer, and they're in there for, I'd say, 23 seconds, and then you hear gunfire. Then there's a 4-second pause, and then you hear another round of gunfire. So Weaver, the sole shooter, shoots and kills Anthony Gallo in roughly less than 75 seconds upon arriving on scene. And Weaver says, oh, well, he had the knife and he made a move on me. So factually what happens is Gallo is not committing a crime. When they view him, he's just standing there. He runs away from them, which is passive. Weaver and Schaefer immediately go into the trailer. They're told by the mom no one else is in there, and she had just been in the trailer. They go right in, and Gallo, a second time, runs away from them. He runs away down the hallway of the trailer to the back bedroom. Instead of just staying at the front of the trailer and assessing the situation, which through their use of force training, of course, they're taught to assess the situation. What's actually going on? Well, Gallo starts running away from them, and Weaver and Schaefer immediately follow him, running right behind him, like 1.5 feet, 2 feet right behind him, which is just bad police tactics aside from everything else. And as Gallo's running away from them, he says, shoot me, just shoot me. So they know that he's having a mental health breakdown, if they didn't know that already. And in their use of force policy, they also have a separate policy, the CERT team, called the CERT team. And one of the very early criteria in calling the CERT team, Special Emergency Response Team, is if a suspect or a subject threatens suicide, which Gallo did. Did they call the CERT team? No. And they follow Gallo to the back hallway, and there's a bedroom, and he turns around, and he's standing there. And they're just a few feet from him with AR-15s. Now, critically, in their own training, use of force training, it's called the 21-foot rule. And the state police are trained for their own safety that if a suspect has a knife, they are to stay 21 feet away from the suspect, because the troopers themselves are in jeopardy if they're deemed less than 21 feet away from the suspect. So they violated their own training by following him down the hallway just 1.5 feet or 2 feet behind him. They're supposed to stay back. That protects them. For whatever reason, because Weaver just chose to do this, he chose to escalate, not de-escalate. Weaver puts himself, and Schaefer's right behind him to the side, within what Weaver says is arm's length from Gallo. Gallo's standing there with the knife in his hand. They're giving him commands. Now, again, when they give him commands also, this was terrible tactics. It's supposed to be one of the two troopers giving a command. Just one giving a command, and you give one command. Well, here they're both yelling commands, and they're yelling different commands. So again, he's having a mental health episode. He's having a breakdown. So he's not thinking clearly to begin with. Well, between the two troopers, they're both shouting commands. They're giving him different commands. One saying, put your hands up. The other saying, get on the ground. Then drop the knife. So Schaefer describes, the non-shooter, no movement by Gallo toward Weaver. He can see Gallo's body. Schaefer's right there. Weaver claims, Gallo made a movement toward me with his knife, and I feared for my life, so I shoot him. Weaver shoots him 5 times at point-blank range with an AR-15, Gallo, right in the chest. And I never believed for 1 millisecond that Gallo made a move on Weaver. Also, Weaver's claim, I was in fear for my life because I was within 1 to 2 feet of him. Well, that's because Weaver chose to violate his own policy and close the distance. Gallo ran away from them into the trailer, then he ran away from them again, which is passive. And under qualified immunity and reasonableness in a use of force, one of the primary factors was the subject engaging in passive resistance or active resistance. Active meaning take a step toward them, threaten them verbally or physically with the knife, throw a punch. Here, Gallo at most is engaging in passive resistance. So Weaver shoots him 5 times in the chest, blows Gallo back onto this bed in the bedroom. Still has the knife in his hand. And then Gallo is on the bed and his body is spasming and quivering. Weaver makes up and lies and says, oh, Gallo, in his deposition, he says, Gallo got up off the bed. Now, there was only marijuana in Gallo's system. Gallo got up off the bed, took a step toward me with the knife, and so I had to shoot him 5 more times. And I said, well, highly unlikely to say the least. Explain, Schaefer never says on the second round of shots, Gallo gets up off the bed. So Weaver fires 5 more shots into Gallo's body, 3 in the back, 1 in the lower left back, 2 in the lower left buttocks. After shooting him 5 times in the chest, Gallo's on the bed, 5 more shots. I mean, unbelievably barbaric, brutal, and beyond unnecessary and unreasonable. Sorry, that's a very long answer, but that's the factual scenario.
No, that's, I mean, obviously horrible, but captivating at the same time. At the point that this case comes into you, you have the family's description. Had there been an internal investigation with statements from the 2 troopers at this point, and I'm guessing other people?
Yes, and then there was a coroner's inquest, and this was interesting. So in Washington County, there's a lot of, let's say, interesting things going on all the time. So there was a coroner's inquest. Now, I've participated on behalf of victims in coroner's inquests in Fayette County, Somerset County, Allegheny County. And so I'm familiar with the process of coroner's inquest. And there had been a recent coroner's inquest involving a jail suicide, and another friend of mine, a lawyer, was allowed to participate on behalf of the victim's family in the inquest. So this coroner's inquest for Trooper Weaver and this shooting of Anthony Gallo, total sham. I wasn't allowed to participate. I said, what are you talking about? I always participate, and you had one here 6 months ago, and my friend participated and asked questions. No, that's not how we do it in Washington County. I said, I know how we do things here. So I wasn't allowed to participate. So the coroner's inquest was a total sham. They hid Schaefer, they hid Weaver, they didn't have them appear. They played snippets of their recorded interviews and the softball questions that the state police, of course, the state police, what do? They investigate themselves. Lovely. So the state police homicide investigator is interviewing Weaver and Schaefer, and on the recording is saying, okay, and so Gallo did this or that. Oh, and boy, you were afraid for your life, weren't you? I mean, so blatantly leading, it was just nauseating. Useless. Then the only witness I recall they called the inquest is the state police use of force trainer to get his opinion, surprise, surprise, that this is justified. The DA of Washington County says that's enough for me. This is justified. Goodbye. So the coroner's inquest is a sham. So I knew enough instinctively when you kill someone within less than 75 seconds. I mean, they did nothing to assess the scene, assess the situation, or even attempt any de-escalation. So I said, that's enough for me. We have a case. Let's file a suit. And so we did.
So to file suit, you don't need any certificate of merits for a civil rights case, right?
No, you do not.
Did you at some point consult with some type of expert on excessive force or policies, training, etc.?
Yeah, so I hired a phenomenal, excellent use of force expert out of Philadelphia. His name is Emmanuel Capelson. At that point, I had not used him. I've since used him in 2 other cases. He's in national cases all over the place. Former law enforcement officer, totally honest, totally by the book. And he said, absolutely, this is excessive. This is unnecessary. They have troopers backing up. Just stay outside of the trailer. You can throw tear gas canister. I mean, what are you doing? So he had a very strong opinion very quickly. So there were competing use of force experts in the case. No certificate of merit required for them. And then in the autopsy, I've had tons of murder cases as a criminal defense lawyer, and sometimes the prosecutor at the autopsy will use some language that kind of camouflages things. Uh, so here, the 3 shots to the back, they were characterized as shots in the loin. So if you read the autopsy report, which I read, 31 times, and I'm looking at the photographs, clearly there's 3 shots to the low back, 1 to the low back and 2 left buttock, but it's at the loin. So I also hired a forensic pathologist, Dr. Eric Vey, Erie County, to clarify for the jury, this isn't the loin, this is the back and the left buttock, because the language there was ambiguously stated, intentional, I'm sure. And so the jury needed to be clear. I mean, they saw the photos, but I wanted to be crystal clear. These are 3 shots to the back, and typically 3 shots to the back is going to be unreasonable force.
Who did you depose in the course of the discovery? Obviously, Weaver, Schaefer. Who were there any other key witnesses in the workup of the case?
Yes, I also named 4 supervisors of Weaver. So Weaver started with the state police in 2008. I got his personnel file, and he had a disciplinary record, and they call it incidents. And there were 36 of them. So this is a combination of complaints generally, complaints of excessive force, internal affairs division investigations. 36 total by the time I got the report. And that was, so I'd say 33 incidents before this Gallo shooting. And I also got all the underlying records of each incident. And for instance, he's on the force a year or 2. Weaver, DUI pullover. The woman, not even the DUI driver, just the passenger, is a little chirpy. She's running her mouth at Weaver. What's Weaver do? He takes her into custody. I mean, she hasn't even committed a crime. He takes her into the barracks. This is back in 09, 010. He shackles this woman, her ankles to a table, and handcuffs her to a table. She's not even the DUI motorist. She's just the passenger who was running her mouth. No crime committed by her, illegally in custody, and then Weaver handcuffs her and shackles her to a table. Then what does Weaver do? He pepper sprays her in the eyes 2 separate times. Weaver is not even apologetic about any of this in his deposition, discovery deposition. I said, and why did you do that? Well, she wouldn't do what I told her to do. What'd you tell her to do? I told her to shut up. I said, all right, did it cross your mind that you illegally have her in your custody and this was a false arrest and false imprisonment of her by you? How about use of force? Pepper spray is a use of force. That she wouldn't shut up in no way justifies you to pepper spray her, let alone in the eyes twice. So she sued Weaver, and they paid out on that, the state police. That's only, he's a year or 2 under his belt. Then he amasses this record where a DUI pullover, he pulls his Glock on the driver, and he's pointing his gun on a DUI pullover. He has another DUI pullover. He tases the driver. On and on and on. So I sued 4 of his supervisors. Now, the state police is very good at constantly moving supervisors around. I was here, I was at that barracks, over to this barracks. So he had different supervisors at different points in time. But most certainly, of the 4 supervisors I named, they were on notice that he had a propensity and this history of escalating and using excessive force. So I named Weaver for excessive force, and then the 4 supervisors for supervisory liability. And unfortunately, Judge Colville denied the defense motion in limine on supervisory liability, but then restricted me to calling the supervisors outside the presence of the jury. So I said, wait, I'm sorry?
What does that mean?
Okay, I don't even know. I mean, so I call supervisor. I'm in my case in chief. I put my case on Schaefer, Weaver. Now I'm going to put the supervisors on. And the defense attorney says, well, objection, Noah, over at sidebar, objection. These supervisors are going to deny any knowledge of his prior history. I said, okay, is this an objection? What are you doing? I'm calling my next witness. I'm in my case in chief. Well, they're going to deny that. I don't care what they're going to say, and most especially what you represent to me they're going to say. We don't know what I'm going to get them to say. And then the defense attorney, who I like and respect, he says, well, you need an admission. An admission of what? He said, actual knowledge that they knew about this. I said, I don't need an admission. So what are you talking about? I said, of course they're going to deny knowledge, and that's a credibility for the jury. Also, I'm not restricted to direct evidence. So in employment cases, just like civil rights, you have to prove the employer's motive, intent, knowledge. It's very difficult for a plaintiff to prove that with direct evidence. So most certainly, any litigant in America is allowed to use circumstantial evidence. So the judge, and I had no idea what was going on, says, no, you do need an admission. I said, an admission by the supervisors that they had actual knowledge? Yes. I said, no, I don't. It's constructive knowledge. No, I don't. You're holding me to a burden that doesn't exist in the law. So then the judge says, well, you can call them, but it's going to be outside the presence of the jury. I said, how about in the presence of the jury? I said, if you're going to grant a Rule 50 motion on supervisory liability, which was clearly what this was looking like, I said, I'm entitled to call them in front of the jury and for the jury to hear this. No. So I had to call the 4 supervisors in my case in chief outside the presence of the jury. And then, of course, they all, with glee, oh, no, I never saw that. I never even heard of Weaver. I didn't know anything. Then, and this was bothersome, I had two eyewitnesses. Weaver, the shooter, 9 days before he kills Gallo, he goes crazy and he pulls an AR-15 on these 2 women. They are at the workplace in the middle of the day, lunchtime in Washington, PA. This is 9 days before he kills Gallo. So the context is the trial judge said, all right, Noah, on the motions in limine, you cannot offer prior uses of force by Weaver because that shows propensity. I said, well, but it's reasonableness. It's reasonableness. And if I show a clear pattern where he escalates and he has the intent and motive to escalate, that's unreasonable. So his priors come in. So Colville said, nah, his prior uses of force can come in against the supervisors, not against Weaver. I said, I don't like that, but fair enough. So after I called the 4 supervisors, not in the presence of the jury, who's your next witness? I said, these 2 women. Weaver went nuts on them 9 days prior, pulled his AR-15 on a suspected burglary. They're at their own workplace, NovaCare, removing furniture in broad daylight. There's a call that there's a suspected burglary. The defense attorney says, no, this is prejudicial to Weaver. I said, whoa. We already have a limiting instruction on that. It's against the supervisors. It's not against Weaver. And the court has already issued its motion in limine. It's ruling on that, saying this is admissible against the supervisors. So I'm calling these 2 women in front of the jury as to the supervisory liability. No. You're going to call them outside the presence of the jury. What is going on here? So I call these 2 women outside the presence of the jury in my case in chief. These 2 women were totally devastating. They were both crying on the witness stand. About 45 minutes each, they were devastating. So what Weaver made them do 9 days prior, and they both called the state police that day and said, this guy's going to kill somebody. And then 9 days later, he did, Gallo. So the jury didn't get to hear any of this either. So Weaver shows up. They come out of the building, and all of a sudden, they hear, get the fuck down, get the fuck down. He doesn't announce himself as a police officer or a state trooper, and he's positioned himself behind a civilian's truck on the hood, just like this. And as the one woman says, he's like a sniper. She says, we don't even know who's shouting at us and cussing us out and telling us to get on the ground. We didn't even know it was a cop. We thought it could be like a mass shooter, some madman. Yeah. So they start bawling immediately. They're on the ground in pavement. They're at work, and they're saying, we work here. Can we show you ID? Shut the fuck up. Shut the fuck up. Other troopers show up. They try to get Weaver to simmer down. They can't get him to simmer down. He's still pointing the AR-15. He makes these women get on their knees. Chad Weaver get on their knees in front of the other troopers and makes the other troopers handcuff these women behind their back on their knees in the gravel after they've already identified themselves as, we work here. We're not committing a burglary. What the hell are you doing? Okay. Weaver then has the other troopers put them each in the back of a squad car for like 45 minutes. They both go home. They're traumatized to this day. They were both crying on the witness stand. They called the state police that day or the next day and said, Chad Weaver, whoever just went nuts on us, he's going to kill somebody. The state police poo-poos that, does nothing, and 9 days later, he kills Gallo. So the 2 women testify devastatingly outside the presence of the jury. And then the trial judge ruled, that's not coming in even as the supervisors. And I said, but judge, you've reversed yourself. You granted the motion in limine Me, you permitted this against the supervisors. I'm still in my case in chief. I said, we are not at Rule 50 yet. I said, if you're going to grant the Rule 50 motion and let the supervisors out, you can do that then, but this is premature. You can't gut my case and not let me put witnesses on in the actual presence of the jury. But that's what happened. So the 4 supervisors didn't get to testify in front of the jury, nor did these 2 women. So the jury never heard any of that. So it was very, very, very frustrating day in and day out trying this case.
How long was I can imagine, first off, I can imagine, and I shouldn't be sitting here sort of laughing, but I mean, what you were telling me that was happening is just so insane. It's sort of weirdly hard not to laugh. How just crazy that this was in lead up. That this officer had this kind of a track record for that long. It's just that just blows me away. How long was the trial, Noah?
I think it was 9 days. 9 days.
Okay. So let me rewind a little bit. So you run somehow procedurally, you get your day in court, which is unusual, right? In these kind of cases. In my experience, the jury selection in federal court is pretty minimal. Was that the case in your situation?
Extremely minimal. And now I have to state, so the defense filed post-trial motions on this case. I don't know where that's going to go. I don't think that it has much merit. But yeah, the jury selection, I'm always very thoughtful. Try to have thought-provoking questions of the jury to really flesh out true bias and so forth. But the jury selection was cursory. And I read lawyers in other states, of course, they get to ask questions for hours and days, even on a routine case. And this is a death case. Yeah, so very frustrating. Yes, very cursory.
Was it, did my experience has been in both instances that I've tried federal cases, the judge just did it. And I basically wound up with, picking from the first 24, whatever was people. I didn't, there was no cause challenges because how can you strike someone for a cause when they're basically just telling you their name and age and what they do for a living and nothing else?
Yes, it was, it was a little bit more than that, just a smidgen. And on cause challenges, so 8 jurors, by the way, on the federal civil cases, has to be unanimous, 8 jurors. So woman comes in, my dad, I think her dad may have been deceased, but it was chief of police. Her uncle, chief of police. The trial judge, but can you be fair? If I tell you, you have to be fair. Can you be fair? Well, I guess. I moved to strike her for cause, obviously. Denied. So of my 8 jurors, of course, I have to get all 8 to win. Before I even open, one of my jurors, her dad is a chief of police and her uncle. Okay? So
was she on your ultimate pin? Was she on
yes,
one of your jurors?
Yes.
Wait, but how come you weren't able to get her out on a peremptory? Because there were
Well, yeah,
more problematic people out there.
Yeah, I had, as of life would have it, there was a disproportionate number of people who had relatives and close friends who were police officers. For instance, so I had 3 peremptories. There was another woman. My best friend is a cop, and her husband's a cop. They're my 2 best friends. They're cops. And my nephew is a state trooper. And my neighbors, or someone else, 4 cops. And this lady says, I don't think I can be fair. She volunteers. I don't think I can be fair. And the trial judge rehabs her into saying, well, I guess I can be fair, I think. And then I think I do a pretty good cause challenge at this point, 30 years doing this. Cause challenge denied. Her nephew was a state trooper. So I only have 3 peremptories. So I had to use my 3 peremptories on other people who had friends. And I end up, of my 8 jurors, daughter and niece of 2 chiefs of police in a police case. Just lovely.
Yeah, amazing. What were you able to get any questions that you had formulated incorporated into the voir dire process, asked by the judge, or not necessarily?
I submitted about 28 questions. I think maybe a couple were woven in there. The trial court did his own. To me, I was not satisfied. There was nothing probing in there. Of course, I wanted. I really didn't get much in the way there of what I would have liked. Just a handful of questions.
Tell me about your opening. And now I'm particularly interested in your opening because I'm assuming that you probably believed there would be certain witnesses that would absolutely come into your case that you later find out aren't going to be, shown to the jury at all. So how did some of the later rulings impact it? And what was your overall approach to the opening in a case like this?
In my opening, every case I let it all hang out. I think I'm a bit of a risk taker. I let it all hang out. I don't believe in, well, don't overpromise, because if you don't fully deliver this type of thing, I mean, you have to show that the strength of your conviction in the cause and the case. So I had no idea how the rulings were going to go after my opening, but very aggressive in my opening. And then I spoke quite a bit in damages in my opening. I think that's underplayed by plaintiffs' attorneys. They may feel, well, I don't want to get ahead of myself. If I'm talking too much about damages in my opening, does the jury think I'm overconfident? Am I overconfident? And there's always a downplay of the damages in opening. And I specifically, when I structure my opening, I try to carve out how much of my opening I'm going to devote to damages. And I try to make it as much as possible with still, of course, connecting with the jury on liability. So if that answers your question, I thought my opening went extremely well. I was very happy with it.
Did you frame it around like a rule or anything like that? Or did you just like tell them the story of what happened and just how absurd this entire situation was that led to Anthony Gallo's death?
Little about a little bit about here's what excessive force is. Excessive force is illegal. It has to be reasonable force. And at every step in the encounter with Gallo, Weaver with his AR-15, not a taser, not pepper spray. It's excessive. It's excessive. It's excessive. And then ultimately, on the key fact whether Gallo took the knife or not, Schaefer didn't unequivocally contradict Weaver. He's hedging, he's trying to save Weaver. So at times, Schaefer says, well, Gallo could have made a move with the knife. I was behind Weaver, this type of thing. But I kind of characterized it as far as you're not allowed to use excessive force. He did, period. That's it. And then also the extreme, I had good facts, obviously, the extreme nature of the five extra shots, 3 in the back, and just the time frame. They're on scene less than 75 seconds. The poor guy's dead. 34 years old, plus he has a 15-year-old son who, of course, was, in the front pew in the gallery. So kind of a combination of the things you mentioned.
How did the defense respond in their opening? What was the thrust of their defense?
In these civil rights cases, just like you can kind of predict it's well,
Feared for his life, that kind of stuff.
Noah's doing Monday morning quarterback in 2020 hindsight. So in my opening, I of course say those things. I said, I'm looking at this exactly as Trooper Weaver was dealing with it. In the moment, frame by frame. Let's go through it together. I am not looking at it here saying he should have done this and these type of things. So they essentially were relying on the unpredictable nature. And there's this catchphrase in civil rights cases where, police officers are always dealing with rapidly evolving tense situations. And the law and jurisprudence and civil rights, of course, is totally, pro-cop, almost cartoonishly so. So they did all the platitudes and, this type of thing in their opening. There was nothing in their opening that I was not expecting.
And then, putting aside the different witnesses you talked about, the supervisors, these, 2 poor women that were held at gunpoint by Weaver that did not ultimately get presented to the jury. What was your order of proof? How did you lay your case out?
Yeah, thank you. Good question. I had to call Weaver in my case in chief. So I called the mother, a couple witnesses from the trailer park, then I called Schaefer as for cross, Weaver as for cross. I also called their use of force expert as for cross because I had my guy out of town, Philly. So I didn't want to have my use of force expert testifies. He goes back to Philly 2 days later, their use of force. Now, of course, I could have him come back, but I called their use of force expert out of turn in my case, and I called the 4 supervisors as for cross. So I pretty much, and then I called damage witnesses. So the bulk of my case was calling all the defendants as for cross and other state police personnel and supervisors as for cross.
No, when you first accepted the case or were looking at it, were you aware at that point, or did you have reason to believe at that point that Schaefer, Weaver's partner, was likely or had essentially described the events somewhat differently than how Weaver contended it unfolded?
Yes, Schaefer, again, he's crafty. He's trying to protect Weaver. So, and these interviews with the state police and the internal affairs division, I mean, God almighty, they're just testifying for Schaefer. So again, there are snippets where Schaefer appears to be contradicting Weaver. And then there are other times where he's flush. He's flush with Weaver. So, but I knew from the snippets, you can just instinctively, I knew that, I don't know, I thought I knew instinctively what the truth was. The guy didn't make a move towards them. And so I was just able through Schaefer was my first witness. I think I called him on, then I called Schaefer as for cross. And it went well with nailing him down to Gallo never pulled a knife. Now, again, then when they stand up and ask him questions, he's saying what they want to, he's saying opposite what he just told me. But we went very well for us with Schaefer and nailing him down, that he saw everything. He's right there. He's 1.5 feet from Gallo. Gallo makes no move with the knife.
Had you pinned him down pretty well on those points in discovery and your deposition?
Yes. Okay. As well as Weaver. Yes.
And because I want to go through, this will be a first for the podcast if you'll humor me, but I want to go through a little bit of your actual cross-exam of Weaver because I just thought it was so compelling. We won't do the whole thing, but the idea is that you really were able to juxtapose and show Weaver, who's the bad actor, as totally incredible because his version of events is pretty diametrically different than what his partner, who's the eyewitness, the only eyewitness there other than Weaver about what happened. And so you get Schaefer nailed down. This is what happened. Anthony Gallo did not lunge. He did not, do a lot of what Weaver said. And you've got, you've got, then Weaver, him ready to go. Now, do you have your transcript in front of you?
Yes.
All right. Okay. So you were kind enough to share this with me. We're not going to do the whole thing. I'm thinking we'll do like these first 3.5 pages. I just thought they were so good. And this will kind of remind me of when I was a young lawyer and I had to go to trials that my bosses were trying and they'd make me go up and be the witness who wasn't there in court. So we'll do that again. So I'm going to be Weaver and you be you. And let's start at the top of this testimony.
Okay, now if I may, so as a little context for the listeners, so in the opening, okay, so Weaver gives statements, Schaefer gives statements. They give statements to PSP homicide. They give statements to internal affairs. Then I take their depositions. And in opening statement, the defense attorney stands up and partway through, early in his opening, he says, "Come get me, come get me." That's what Gallo said to the 2 troopers before he ran into the trailer. Now, I'm thinking, well, I've never heard that before. And I'm thinking, I don't know how well thought out this is because even if he says, "Come get me," you can't kill him. But in any event, so that's how I started my cross of Weaver, just so the listeners maybe are cued in on that.
All right.
So let's say, okay, page 2, line 5. So I say, "Good morning."
Good morning, sir. How are you?
Come get me, come get me. Is that what you're now claiming today, now for the first time, that Anthony Gallo said to you outside that trailer?
Yes, that's what he said.
And you gave a statement to someone from the state police a few weeks after this happened, 7 years ago, Boyd Was, and you made no mention of this, come get me, come get me. True?
That's true.
And then you gave another statement to another employee of the state police, last name Missouri, and he interviewed you about the situation as well, correct?
Yes.
And you made no mention at that time about Gallo saying, come get me, come get me. Do you agree?
Yes.
And then under oath, I took in what's called a deposition. I asked you questions, March of 2022. I asked you specifically, tell me everything Gallo said outside that trailer. And you made no mention of come get me, come get me. Do you agree to that?
Yes, I do.
So you have three chances to tell all your version of events. And now for the first time, in this case, you're saying he said to you, come get me, come get me. Is that what you're doing?
Yes, that is.
When did you come up with this come get me, come get me? Was that the other day?
There's objections. Can you repeat the question?
When did you come up for the first time with this new claim that Gallo said, come get me, come get me?
Just the other day.
Got you. Now, even if he said that, come get me, and runs into the trailer, you're not allowed to kill him for disobeying your commands. Do you understand that?
Yes.
And you killed him because he disobeyed your commands, correct?
I shot him because he was holding a deadly weapon and he did not comply with my commands. And he attempted to kill me in the trailer with that deadly weapon in his right hand.
But yet you were here yesterday, correct?
Yes.
You heard Trooper Matthew Schaefer, who was right there, correct?
Yes.
And Schaefer testified under oath Gallo made no moves to you, towards you with this knife. You heard Schaefer say that, correct?
I cannot see what Trooper Schaefer sees. I'm in front of him at that point. I cannot see if he sees him make a move. I have no idea what he's able to see.
Schaefer said he was to your side. He was to your side, and he could see the upper body of Gallo. You heard him say that.
I did.
And Schaefer said he saw no movements whatsoever from Anthony Gallo's body right before you shot Gallo. You heard Schaefer say that, correct?
I did.
And that's because it's the truth. What Schaefer is saying is the truth.
No, it's not the truth.
It's not the truth. You fired out of anger, didn't you?
I fired because he had a knife in his hand and he threatened to kill me. He took a step forward and tried to stab me with a knife. That is why I fired, because I was in fear of death and serious bodily injury. So that we could go on and on, yeah. And I love it. I mean, when he said just the other day, and your spine got you. I mean, I don't know how it's not game over at that point. And then, you go on and do a terrific job at the end by just nailing down, hey, Schaefer, he's a good guy. He's a believable guy. He's a trustworthy guy. And he's saying, yeah. So now it's his partner somehow lying, and this guy should be believed. And that had to be, it had to be a fun cross. Given everything that you knew, and then you're kind of given that little extra piece that now he's making up a new story. That's great stuff. You talked to me about some of the, frustrating rulings, and hey, look, that's part of being a trial lawyer. We get, frustrating rulings, and sometimes we get rulings that go our way, and sometimes we get ones that don't. You rolled with the punches, obviously. Were there any other moments? Obviously, Weaver's testimony had to be just so impactful to the jury. Were there any other moments that the jury did get to participate in that you thought were particularly poignant or effective in leading to this verdict?
Yes. I did realize, okay, the case is going to be won on cross-exam, if it was going to be won. And again, I had good facts. The state police, they call a use of force expert. He's employed by the state police. They don't even get an outside, independent, objective expert. And what is that? Good for me. And my use of force expert Emmanuel Campbellson was just devastating to the defense, in my view. Two things happened, one in front of the jury, one not, that were very frustrating. So on punitive damages in a government case, you can't get punitive damages against the entity, but you can get it against the individual officer. And then behind the scenes,
they're on the hook for it.
They can indemnify the officer. Okay, so here, sure. Although the defense will never put this in a discovery answer, they'll never answer and say, we're going to indemnify Weaver. I knew that they were going to. So in the standard jury instruction on punitive damages in civil rights case, it talks about indemnification of the officer. And so if Weaver was not indemnified, Weaver could have put on, for the jury's consideration on punitives, his wealth or lack thereof. So he's got a 60 grand equity in his home and 3 grand in the bank or what have, to say, don't hit me with punitives because this is my financial status. So I knew they're going to indemnify the state police. So interestingly enough, and the number is so large, it's humorous, although this is a tragic case, $1,400,000,000. That is the budget of the Pennsylvania State Police annually. So in chambers, before I close, we're doing jury instructions, I said, well, I'm arguing the wealth of the defendant, and the wealth of the defendant here is the state police, because even though it's Weaver in his individual capacity, they've chosen to indemnify him, and the jury is going to be misled. If I don't say the big number, they're going to think, oh, geez, Weaver is going to have to pay the punitives, and he and his wife there every day. They're going to say, these are little people, we're not going to do big punitives. So I said, I have the right to offer to the record the wealth of the defendant, the payor, which is the state police. And so the judge didn't like that. He said, I think his analogy was, wait a minute, if I'm sued and Bill Gates is my uncle and he's going to just pay my verdict, does the jury get to know his net worth? I said, I don't know about Bill Gates, but this is the employer of Weaver. This is an employer-employee relationship. And when the state police is paying the freight, the jury has the right to know that, or at least to infer from what's offered in the way of assets or lack thereof in punitives as a help to the jury, as a factor in how to properly assess punitives, the wealth, the budget of the state police. So, of course, the number was so big, $1,400,000,000, and the defense instinctively says, no, that's not coming in. The judge says, that's not coming in. I said, that's not fair to me. All right, now, also, as you may know, in front of the jury, I'm in my closing, and there's the single-digit ratio. So it's in the standard jury instruction. So to not violate a defendant's due process rights,
is it 10-1 or
right,
5-1?
Right. So I say single-digit ratio. I'm about to say to the jury in my closing, I'm about to say, to be safe, it cannot exceed 9-1. And of course, I can't say what I'm asking for in compensatory, but I'm about to argue the single-digit ratio, which I've done before in other cases. It's never drawn an objection, ever. It's in the note to the standard jury instruction. My closing gets interrupted. Noah's going to say the single-digit ratio, and that's prejudicial. I said, no, it's not prejudicial. You wouldn't let me get the wealth in. Now you're not letting me argue. I said the jury has a right. It's in there for a reason. They are entitled to guidance on how to assess punitives, no punitives, or how much. I said they have a right to guidance. You're not letting me give them the wealth or the single-digit ratio. I said, this is totally denying me a fair trial. I said, also, this is for the protection of Weaver. For the single-digit ratio is to protect him. So this is a correct statement of the law. It's neutral. How am I not allowed to argue this? And the judge says, well, yeah, but that single-digit ratio, that's in the note to the instruction. I said, everything of consequence is in the note. You have the model instruction, there's the model, then the note, and everything of consequence. So my closing was interrupted. I didn't get to argue that either to the jury. So compensatory damages were $10 million, punitives were $11 million. I very much like to think that had I been able to argue the single-digit ratio to the jury, punitives would have been higher. And had the jury heard these two women who had this interaction with Weaver 9 days prior, It was, I've had probably three instances like that, three or four in my life in a jury trial, goosebumps, hair raising on these two women. It was so authentic. And the trauma that Weaver did to them, the jury, it would have been much higher verdict had the jury been able to hear those two women, even if I had not been allowed to argue the single digit ratio. I'm not just saying that. I really feel that those two women were heroes, and sadly, the jury never got to hear them. But the interruption of my closing and being precluded from arguing the single digit ratio, I thought was error, and that was also frustrating.
Are you appealing on your own basis in some of those regards?
Yes. So the defense filed post-trial motions, and I filed a notice of appeal to the Third Circuit because of somehow, I don't think this is going to be reversed, but I mean, the ruling on the supervisory liability, I think, is very questionable. So to protect my client's rights and interests, I filed a notice of appeal as well.
In your, you were precluded from the single digit reference. You were not able to talk about, the financial status of the Commonwealth. Did Weaver's, like, his financial information come in to
No, they did not
closings?
offer it. They did not
Okay.
offer it. And I think they argued that point. And I said, it doesn't matter if you don't offer it. I said, the reasonable inference from a jury, unless they're told otherwise, is that Weaver's going to be paying the freight personally. And I said, that's misleading. I said, it's a fact here. They're indemnifying Weaver. There's a legal consequence. When they choose to indemnify him, there's a legal consequence. And the legal consequence is the jury's allowed to know what the budget is, the net wealth of the defendants. So then the jury says, oh, okay, it's not Weaver. His employer is paying this, which they're entitled to know, in my view, clearly.
So I assume the judge must have ruled that you were permitted to argue and seek punitive damages before closing, right?
Yes.
Okay. And when was that decision made? Following a close of defendant's case or following your case?
I thought it was honorable by the defense counsel, Scott Bradley. I mean, in our proposed joint instructions, he even included punitives. There was no way this isn't a punitive damages case. It's an intentional killing, the second round of shots. So I didn't get any resistance from the defense on that, which I appreciated.
And when you're going to get to argue punitives, albeit you don't get to talk numbers. I read in the Trib Live article that chronicled the story of the case. You talk to the jury about sending a message about this kind of behavior and so forth. Can you share with me any of the other arguments that you remember conveying to the jury about the importance of their verdict in that case?
Sure, thank you. So on punitive damages, of course, it says one of the factors is the reprehensibility of the conduct. And I emphasized to the jury, I said, folks, this was a death case. It doesn't get any more serious than this. And here, the key thing before you is the nature of the death. I say there's sometimes a car accident case where someone's momentarily looking out the window, and that's negligence and they kill someone. But all they did was look out the window for 1 second. Or if a doctor in a med mal case is trying to help someone and there's a medical error and someone dies, but the doctor's trying to help the person. I said, here, this is not this situation at all. This is a intentional killing, a brutal killing. There was no move made with the knife. This is a civil case. No one's going to prison. No one's going to jail. But on punitive damages, your verdict has to be substantial. It has to be substantial in light of the nature of the killing here. And of course, the overwhelming, I said, the nature of the loss to Gallo's son, Anthony, 15-year-old at the time, that's overwhelming loss. So therefore, I said the amount of punitive damages should be overwhelming.
That's great. Do you have any, with no guidance, as you pointed out, do you have a sense of the numbers that, where they came from that the jury settled on, 10 and 11?
I didn't. I didn't get to talk to the jurors. I always love to do that, of course. And I don't know, sometimes in the federal courthouse, you're waiting, and then they slip out the other entrance. So I didn't get to talk to them. I thought maybe reach out. I don't know if I have the jury questionnaire, but I would have loved to talk. But I do feel, had I been able to argue the single digit ratio and or they heard those two women speak, I mean, it was so powerful and such a visceral reaction. I think it would have been high, but it was 3 million for shooting Gallo for his, for being shot to death 10 times. 3 million. I thought
So
that
his
was
his survival claim, basically.
correct, and then
Okay,
7 million for the son, the companionship, losing the companionship of his dad. 3 million plus seven is the 10, and then the 11 in the punitives.
gotcha. As you look back on your career, but this case, um, obviously as you mentioned, you had really powerful facts in this case. But for say a young lawyer getting into civil rights work and they're finding themselves with an excessive force case, I mean, do you have any advice for not that they could ever try a case just like you tried in this case? They're going to have different facts, but I mean, what's your advice to younger lawyers coming up that are interested in trying a civil rights case on the keys to success long term?
Um, they can call me. I'm very busy, but they can call me. A lot of lawyers help me. There's a 1983 Section 1983 handbook, Walters Kluwer. It's always black, red, and gold. There's different treatises on civil rights. I get that every year. I feel that's like the true Bible. And I mean, I did criminal defense work, so I got a lot of overflow from my criminal cases to file suits on civil rights actions. I guess maybe if that was a way. But I would just ask other lawyers. They can call me. Look at the Bible. I don't think it's an ocean of law in civil rights jurisprudence by any means, but it most certainly is stacked against you. And with these procedural hurdles where they can take it up on Rule 12, they can take it up on Rule 56, you got to be extraordinarily patient in these cases, because if you do get the trial, this was 7 years, and I've had ones that were longer because of these interlocutory appeals in these civil rights cases. So you have to be very patient, and your clients have to be patient. Anybody who comes into me on a civil rights case, I say, I do everything for the long haul. Don't tell me that you're all excited about 2.5 years. You call me and you're moving to Tennessee, or your car broke down and you just get these are long haul cases, as are a lot of these cases that you handle, Brendan.
Yeah, for sure. And I guess I'll end with kind of an observation about trial practice and kind of an observation about you. And it's this. So when you're talking about your opening and you say, you take chances and you let it all hang out and you're not pulling punches in opening, there's a lot of lawyers, that would say, oh no, you got to be, off code and, you got to play it down. Don't over advocate in opening. And I think for me, for example, I think that's actually good advice, but I think that there is not a one size fits all. And when I listen to you talk about this case, you're fired up about it, but I don't even get a whiff of anything less than that you truly believe in this case. You know what I mean? Like, and I think that, by you just letting it hang out and being yourself in your opening, I could imagine, like, just sitting here listening to you, that a jury, they're not going to be like, oh, here we go, personal injury lawyer looking for a big payday. I think just listening to you with the facts of this case and you describe them, again, I think it's captivating. It's, I think this word's overused, but it's authentic. And, I could see how, you had this case from what I would guess from opening statement, and then you were rolling, and if anything, you were probably held back from, like you said, getting an even, potentially larger recovery. I mean, it's hard to get much bigger than 21 million now. I mean, that's an unbelievable outcome for the family, for you, I think, for what it speaks for. do you have a sense of, whether there will be any, repercussions for Officer Weaver out of this?
Great question. No, there will be no repercussions. He's still employed by the state police. And on his disciplinary action jacket, he was put over at the casino in Washington. Just watch video, okay? He's gotten in a couple instances over there of excessive force. A guy dined and dashed allegedly on a bill in the casino. This is in their files. I got in discovery. I wasn't allowed to get into any post-event excessive force, but it's discretionary. Sometimes you can get into post-event excessive force to show the likelihood in the instance, but that didn't come in. But Weaver comes down. A guy dines and dashes on a bill. He's suspected of that. Weaver takes the guy to the ground, and the allegation is the guy has a fracture of a cervical vertebrae in his neck. This is Weaver. This is a year or two ago. This is after he killed Gallo. He's still employed there. I mean, how much was the bill? If the guy wanted some eggs and some bacon, is the bill $7.99? Do we really have to take him to the ground? It really was mystifying to me. It was like Weaver must have been the great-great-great-grandson of the original commissioner of the state police.
Yeah, I was thinking the same thing when you're describing this pattern of conduct that, what does he have on somebody important to have been able to maintain his position in spite of everything that he's been doing.
And if I can just say this, so I asked him on one question, he doesn't follow policy, doesn't fill out reports. And all his supervisors are there. They're trying to cover for him desperately. They're trying to cover for him. So I asked Weaver, did you do such and such report per this policy? No. And of course I'm saying, peppering him with, you do whatever you want, don't you? You don't listen to anybody. You do whatever you want. No. Did you follow this policy? Did you do this report? No. And then he actually said, I said, well, did your supervisors come and say, Weaver, you got to fill out this report? No. And then he said, his actual quote was, that would be my supervisor's problem. I mean, they're there desperately straining to cover for him. And in front of them, Weaver says, that's their problem. That would be their problem. Like no regard for the state police or his supervisors for protocol, the right thing, but yet they're straining to protect him. It was bizarre. Yes, he's still employed by them as of today.
Yeah, you're right. That is mystifying. Well, no, this is just. I said this to Rob when we were going on. I said this is a wild case, and the way you told the story was even. I hate the word they use, entertaining, because it's a horrible thing that happened to Anthony Gallo and his family. But the story and what you overcame for the family is just entertaining, amazing, and I appreciate you sharing it. And I, super happy for you and the family to get such an amazing recovery. For anybody that wants to get a hold of you, whether they want to pick your brain, they want to refer you a case, whatever, what's the best way for people to get a hold of Noah Geary?
Sure, thank you. So phone number 724-222-3788. My email is noahgearylawoffices@gmail.com. And I want to thank you for having me on and your interest in the case. And everybody knows you are an excellent trial lawyer. So I am flattered that you wanted to have me on your show.
No, honestly, I appreciate you saying that, but just an awesome outcome. Story was even better than I expected it to be. And, congrats and thanks for doing this, Noah.
No, thank you, Brendan.
All right. Hope to see you soon in person.
Me too.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.